Good morning. So today we are going to be talking about the myths of probate court. Let's just give it a moment for the different social feeds to connect here, and we will get started. Okay, perfect. So my name is Crista Hermance. I'm an estate planning attorney licensed to practice in California. And this whole week, I have been going live every day to talk about probate court, talking about what probate court is, what assets have to go through probate, how much it costs. And today, I'm going to focus on some of the myths that are associated with probate court. If you are watching this and not located in California, it's still really great information to just know that these are things that potentially could come up in your state, but it's always best to work with an attorney in your state for the most accurate information, especially when it comes to probate court or what those proceedings are. Okay, so if you have any ideas about something you've heard about probate court, please put that in the chat, and I will read it and say if it's a myth or if it's something that's true. But I do have a few myths here that I think are really kind of big things that people think about when it comes to probate court. And if you weren't able to watch the other broadcast that I did on probate, let me just give a quick overview of what probate court is. So probate court is the process that when somebody passes away and they own assets in their individual name, these assets, in order to be able to be distributed to their heirs, would need to go through probate court. And the probate court is the court process that, a petition is filed, notification is sent out, it's published in a newspaper, the assets are gathered, maybe they're sold, and then at the end, when you get to that court hearing, all the creditors at this point have been paid, bills have been paid, and then whatever is left is then distributed to the heirs. So let's get into some of those myths. And again, if you're just joining me, if you know of some fact or myth about probate court, please put it in the chat. I'd love to hear it, so we can either say yes, it's a myth, or nope, that's actually true. Okay, so first myth for probate court. If I have a will, I don't need probate court. What do you think? Is it a myth, or is that true? If you have a will, you don't need probate court. That is a myth. A will alone will not avoid probate court. Basically, all a will is doing is it's telling the probate court, here's how I want my assets distributed when I pass away. Please follow my instructions and distribute according to my instructions, right? So having a will is not going to avoid probate court. Thank you for that. So the way to avoid probate court is by having a trust, right? A trust in your estate plan is going to have your assets listed in the name of your trust, and therefore be able to say there's nothing that would have to go through probate court because it's owned in the name of your trust. It's not owned in your name individually. Okay, so first myth there for you. Having a will does not avoid probate court. Okay, next myth. And again, if you're just joining me, if you know of a probate myth or something that you've heard and you want to know if it's true, please put it in the chat as we are going through those. And I am also giving some of the myths that I think are very common. Okay, next one. Hello, thanks for joining. Probate is quick and easy. Well, in California, probate is not quick and easy. So that is absolutely a myth. Probate court in the state of California, depending on the county, can take anywhere from almost a year from start to finish, upwards of 3 years. In the ones that I see, it's generally 1 to 2 years. And this is uncontested. This is everybody's getting along. It's just how long it takes to get put on the court's calendar, to be able to have the probate referee come in and do the assets. Maybe if there's a house that needs to be sold, 1 to 2 years. Okay. And what that means is that the beneficiaries or the heirs of the estate can't actually get access to any of that money until the end of the probate court. Okay, so they have to wait for court approval to be able to actually get that information. Hi, welcome. Thanks for joining. Okay, so we're going over probate myths. If you are watching this in the replay, you can put your questions on. and I can try and get back to it in the next live that I do. But if you are interested in learning more about probate, I am hosting a free webinar tomorrow. So make sure to sign up for that free webinar so that you can learn about all the stuff that I talked about this week, as well as some additional things that I haven't been able to go over. It's also an opportunity for you to be able to ask questions as we go through that information about probate court. And if you know that you need help, right, and you are in California, or maybe you're not in California, but somebody passed away that's in California, and we need to administer probate court in California. Maybe there was a property in California. We do that a lot for out-of-state people where we have to go through probate court. Please just send us a message or put it in the chat that you need help, and we will send you a link to schedule a free consultation for getting that probate meeting started. Or maybe you want to avoid probate court. Maybe this has talked you into understanding, you know what, I actually do need an estate plan. You can schedule a free phone consultation to be able to get that. So just put it in the chat for just put trust in the chat or send us a message, and we'll get that link to you to get that scheduled. Okay, the next myths. We're doing the myths of probate. Next myth: probate isn't expensive. Okay, what do you think? Myth or not a myth? Is probate court expensive? Yes or no? That is a myth. Probate court is very expensive. Just to give you an idea of how expensive probate court is, let's say that there is an estate with a value of $500,000. The cost to go through probate is set by statute by the state of California. A lot of states throughout the country are like this. Some states do it on an hourly basis, but California is specific to statutory fees. So the cost for a $500,000 estate to go through probate is $26,000. That's just the statutory fees. In addition to that statutory fee, you have filing fees, probate referee fees, bond fees, publication fees. That's another $2,000 to $3,000 in cost. That's almost $30,000 for a $500,000 estate to go through probate. And what I'm seeing is that families can't actually afford that. So somebody passes away and the family can't afford to pay those fees, so they're being forced to sell the home to be able to afford to be able to pay the fees from when they've passed, right? Again, these are things that can be avoided by having proper estate plans done, by having a trust, by avoiding probate court, because probate court is very expensive. Okay. Okay. Last myth I have for you. Only the wealthy need estate planning. What do you think? Is that true or false? Only the wealth need estate planning. It's a myth, right? Anybody that is over the age of 18 and or has minor children and a house should have some type of estate plan in place. If you have young adult children and they're going off to college, they should have a power of attorney, advanced healthcare directive, and a HIPAA authorization, right? Because if something happened to them, you want to make sure that you're able to talk to the doctors, know what's going on if they're states away, right? So even 18-year-olds. But for people that own a home or for people that have minor children, having a trust would prevent having to go through probate court. What it's also going to do if there's minor children, since minor children can't inherit money or property if they're under the age of 18, that money would go into a court-blocked account, and then they would get access to it when they turn 18 years old. However, if there was a trust with an estate plan, then that trust would be able to have the instructions of how that money is going to be held for the benefit of the minor children and be able to provide more protections and probably extend it past them receiving it at 18, maybe 25, 30, 35, you know, whatever you want, right? It's your trust. You get to create it. And so you having the ability to say, this is how I want to keep those assets protected from creditors, predators, spouses, ex-spouses, or future spouses that your spouse may have right now, right? Some type of blended family situation. You can put protections in place within your own estate plan to make sure that your kids are protected. Okay. Okay. Those are all the myths that I have for you today. I want to thank you so much for joining me this week on our probate section as we've broken down different parts of probate every day. Join me tomorrow. Make sure to sign up for our free webinar where I'm going to be talking about probate as a whole and as an opportunity for you to ask any questions that you may have. But I will be having that tomorrow at 11 a.m. Pacific time. So please make sure to sign up for that webinar. And again, if you need help with either probate court or estate planning, you have somebody that's passed away, you're not really sure those next steps of what need to be done, or maybe you don't want to be in this situation, right? You don't want your family or your parents or your grandparents to be in this situation. If you are in California or they're in California, we can assist. So please just either put a comment in the chat or send us a message, and we will get back to you on scheduling a free consultation for that appointment. So thank you so much for joining me, and have a wonderful day.